You're listening to our continuing coverage in the trial of Adam Montgomery. Let's now go to the courtroom for segment number 3.
Ladies and gentlemen, this is a remarkably simple case. It's a simple case with tons of evidence. Before we get to the evidence, though, I'm going to remind you of something that Mr. Agati told you in opening. That at the conclusion of this trial, we would be asking you to believe the defendant's words, his admissions to stealing the guns, his admissions to possessing the guns, and his admission to selling the guns for drugs and for money. What the attorney just told you in this case, that's not evidence. The evidence is what you got from the witness stand, from the witnesses that stood here, swore to tell the truth, and testified. They answered question after question. That's the evidence in this case. The evidence in this case is the stipulations that you received over the course of the last few days. The stipulations regarding the defendant's prior criminal history, the communication with Mr. Reed. That's evidence in this case. The story that you just got, that's not evidence in this case. That was created by an attorney. The evidence that you got was from the witnesses. And they told their story. They told a story. Each of them came in and gave you a piece of a large story. What you just got from Attorney Davis, that was her story. And it's not reasonable. That is not a reasonable story. It's unbelievable, and it's not evidence. The best evidence in this case, again, the defendant's words. And we told you that in opening. His words, his admissions to the crime. His words in a Facebook message that's frozen for all of time. I have these guns. This is a remarkably simple case. I want to take a minute to talk about what she just told you. Ishmael Garcia. Let's talk about Ishmael Garcia, the boogeyman in this case. Ishmael had the AR-15 rifle. Ishmael had the shotgun. He was at the crime scene. He obtained these guns. And we're talking about the big guns when we talk about Ishmael Garcia. That he possessed the big guns, the big boys. That he sold or disposed of those guns. And that he brokered these guns for Ishmael Garcia. That's what you were promised in opening, and they doubled down on it. They doubled down on it here today. That's what they told you happened. That's what Attorney Davis just told you, the story that she told you. And let's look at all of the evidence that supports those theories of what happened. All of the evidence that you heard from the witnesses that got up, that told their truth in front of all of you, looked you in the eyes. All of the evidence is right on that screen. All of the evidence of some Ishmael Garcia, the boogeyman, is right there. And while we're talking about what this case is not about, while we're talking about the stories that you've received, when we stand up here in front of this mic, that's not evidence in this case, and I've told you that. But it's not open mic night. We can't just stand up here and say whatever we want. It has to be based on the evidence that came out. It's our summation of that evidence. And when we quote people, we want to use an accurate quotation of what those folks said when they took that stand, or what they said in a previous statement. And is that what you got? It's not. One thing that I agreed with Attorney Smith about, one thing that we got from these stories that we heard from the folks that came here and testified, Attorney Smith said in her closing that Mike Sullivan came up and he told the truth about his interview, what he knew in his 2020 interview. And we talked extensively about that, what he knew. And she said, he told the police that Ish and Manny was there, and he mentioned Adam. Was that what he said? Was that what he testified to when he took the stand? I read his quotations to him. He adopted those. He said, yeah, that's what I said. That's what happened. And what I asked him, you said Ish and Manny took the guns, and Adam. Adam had the guns. I couldn't agree more with what Attorney Davis said. He did tell the information that he knew back in 2020. He said, Adam had the guns. And then he was asked, did you see the guns? And he said, see him, I held them. The shotgun and the AR-15 rifle, I held them. Adam had the guns. That was his statement. He said, yeah, that's what I said. So when we quote people, we want to make sure that we're using the right quotation and we're encompassing the full story. So the surrounding statements that are associated with that quote, not just picking and choosing. He said Adam had the guns, both guns, the big boys, the two long guns that were stolen that night. And he clarified with us. He told us that when he referred to Ishmael, Garcia, and Manny, he was referring to the pistols. That was his evidence. That was his testimony. That was his truth. So there's the evidence of Ishmael Garcia or Manny. And we should have added during closing some phone call between between Ishmael and the defendant. Where did we hear that? Not a part of this case. Speculation by the defense to fit their story. Adam had the guns. There's another concerning thing that you were told just now, and that's that in 2020, the Manchester police wanted everything they could get on that man. Where did we hear that? Did one of the witnesses say that? Why? Why would the Manchester police care about Adam Montgomery? That's not anything we heard in this case. That they were all out to get Adam Montgomery? For what? Because he possessed guns. When he was told 3 or more times, you can't have guns. Felony conviction after felony conviction after felony conviction, being told, no, you cannot have guns. And still he sold them. He stole them. He possessed them. And he distributed them to people in this city, people like Jonathan Sargent, who was apprehended with it shortly after. That's one reason to care about who he is. To concoct stories, to get witnesses to say what you want them to say. What evidence did we hear of that? But they were right. Mr. Sullivan, 2020, came in and told them what he knew. That's what she said. And he did. Adam had the guns. The 2 guns that he's charged with stealing, the 2 guns that he's charged with possessing, and the 2 guns that he's charged with selling or disposing of. The 2 big boys. So there's no evidence of Ishmael Garcia. And that's because it didn't happen. The story that you were just told was just that. It was a story, not based on evidence. I want to continue talking about what this case is not about, ladies and gentlemen. This case, it's not about Mike Sullivan's drug use, his drug addiction, his charge for petty possession. This case is not about that. It's not about Kim Frayne being slumped over, sleeping in a car with drugs on her person. It's not about her drug use. It's not about her addiction. This case isn't about Mark Reed. It's not about the things that he told you he did on the stand, like do drugs, sell meth, sell crack, sell heroin. This case isn't about that. This case isn't about Kayla Montgomery, her drug use. It's not about her conviction for perjury on another matter. It's not about that. But notice that that's what you got a lot of. These convictions, the drug use. People that came in and were open and honest about some of the roughest times in their lives, things they've fought to get out of. It's not about their drug use, and it's not about their charges or convictions. And the defense wants you to focus on those things. They want you to focus on everything this case isn't about. So at the end of the day, you won't see what this case is really about. That man going into his trusted friend's home, stealing from her, betraying her trust. Her trust as an invited guest. And in the time that followed that, possessing firearms, knowing that he couldn't, selling those firearms for drugs or money. That's what this case is about. Don't let those other things distract you. They're a distraction. So with that out of the way, I want to talk about the theme of our story. I want to talk about something that they didn't. I want to talk about the truth. And again, the truth is what you got from the witnesses. It's true, they raised many questions. Those weren't relevant questions. Those weren't questions that should give any of you any serious pause when you're considering what the real evidence is in this case. They were attempts to distract you. And again, the truth is he stole those guns, that he possessed them, that he sold them. This is a remarkably simple case. Again, the best evidence in this case, not her statements, but his, the defendant's. What the defendant told us, that's what we're asking you to rely on, his words. And what did he tell us? He told us that he stole the guns. That's a pretty big detail. He told us that he possessed the guns. He told us that he sold the guns. And he told us how he did it, who he betrayed to get them. That's the truth of this case. That's the truth that you were given over the last few days, folks. That's the only truth that there is. And how do we know what the defendant said? Well, he made statements. He told witnesses things. The witnesses that testified to his various statements, drastically inconsistent with one another, but with consistencies that matter, and we'll go over those. So we have his various statements. We have the jail call that you folks just heard, that we listened to just an hour and a half ago. And we have his messages. Those messages frozen in time, as Mark Reed told us. And so what was his first statement? His statement to his wife. The first thing he told her about this incident shortly after it occurred. He told her that Kim Frayne was sleeping, that he went to her house. Her door was wide open. Her dog didn't bark. He went there. She was sleeping. He woke her up. She hadn't crashed. She was sleeping. Not crashed. She was asleep. He woke her up and she said, "Oh, my guns are gone." That was the first story that he told. He told his wife. And she came in here and she testified to it. And I guess the rest of that story would have been that he left. And the second story that he told to his wife again, after she confronted him, after she saw him dealing those guns to Ish, to Manny, and to Mike, attempting to sell them what they knew were stolen guns. She confronted him. This was her colleague. This was her friend, a close friend, someone who had done favors for her family. And he told another story. And what was that story? We got it from Miss Montgomery when she took the stand the other day. She told us that he said, that defendant I went in, she was sleeping, the dogs didn't bark. I took the guns, I concealed them in a sheet, and I left. And that's consistent with what she saw. She heard him come home afterwards, and the next day he was trying to broker that deal. He was trying to sell those guns to Ishmael Garcia. He was trying to sell the guns to Manny, and he was trying to sell the guns to Mike, and they said no, because they knew the guns had been stolen. And then we have his third statement, and that's from the jail call, again, that we just listened to. He was there. He was hanging out with her. They were hanging out. She started falling asleep. Again, falling asleep, not crashing, not nodding off. She was falling asleep. He said goodbye, and he jetted. That's the story, the third story that you just got about what happened that evening. And then you also heard a fourth statement from Michael Sullivan. He told us what the defendant said, and he told us the manner in which the defendant said it. He'd been confronted about the cameras that Miss Frayne said her neighbors had pointed at her house. That confrontation while the defendant was doing drugs with Mike Sullivan. And remember what Mike Sullivan said. He said that his wife, the defendant said that his wife was getting ill. She was getting dope sick. He needed more drugs. And I gave him more drugs for his wife to prevent her from being ill. Because it's so bad when you're drug sick. You need more. You need a little more to hold you over so you don't get ill, so you can control your bowels. And that's what was happening to Kayla. And what did the defendant do? What did we hear the defendant did with those drugs that he'd been given for his wife? He took them himself. And why did that matter? Why did it matter that Mr. Sullivan told us that story? It's why he was in the car with him next. It's why he left with him to ensure that the defendant didn't do more drugs that were intended for his wife, to prevent her from becoming ill. And that's when the defendant first told Mike Sullivan that he'd stolen the guns. If she had those cameras, I would already be in jail. Not Ish, not Manny, me. I would be in jail. And we heard that she didn't really have cameras. If she had those cameras, I would already be in jail. And then, ladies and gentlemen, we also have the defendant's own statements, frozen in time. His Facebook messages from the day after he stole the guns, trying to get rid of them. The defense wants you to believe this was him brokering. And I think that means we need to look at the actual messages, and we need to go through those messages, and we need to see what this man is actually saying in those messages, because that tells all. And Your Honor, if the jury can just be told that they can move if they need to see.
You can move if you need to.
And ladies and gentlemen, you'll get these when you go back to deliberate. So the first message, the first call. So this is a call from the defendant to Mr. Reed. And importantly, it's dated October 3rd, 2019 at 10:26 a.m. Yo, Mark, hit me up, dog. I got something you're really gonna like. You gotta hit me up now, ASAP. You're gonna miss out, bro. You don't hit me up right now. Should girl's phone or something to call and call. I got something you're really gonna like. I do. He's not saying Ish, not Manny, not the boogeyman that you haven't heard of. You gotta hit me up now. Not someone else, me. If you don't hit me up now, and he provides phone numbers. And the first one, it appears to be a typo, and he clarifies that in the second number that he provides. And when I say he, I'm referring to the defendant. He sent these messages. That's not in dispute in this case, from his fingertips. And how can they be disputed? 858-3393. That's the number that he provides. Why is that important? He provided that number on October 3rd, 2019. And we heard that when Jonathan Sargent was apprehended with one of the stolen guns, in addition to everything else he had, the meth, the pounds of meth, the money, all those other drugs, or all those other guns rather, that number was in his phone under a contact named Montgomery Adam. And you heard what wasn't in his phone. You heard there was no Ishmael Garcia, no Manny. The police looked. Why would they look for other information that would rule other people or make them suspects in this case if they had blinders on for this man? Why look for evidence that would refute that he was the only person that stole those guns, that he was the only person that possessed those guns, if they had blinders on for one person, for some unknown reason? That number of the defendants tied to that gun, or that man that had that gun in his phone under Montgomery Adam. Someone that was later sentenced to 13 years in prison for possessing that gun. Someone that dealt in meth. And why is that important? We'll get to that. Oh, then you're gonna miss out because I'm not messaging this shit. I'm not messaging this. I don't want it on Messenger. I don't want it on Facebook. I don't want it preserved in time for a future investigation into what I'm doing. I don't want it on Messenger. I'm not messaging it. There's a house phone there. You guys have cell phones out there. You guys have some type of service. And just before that top message there, you're gonna miss out. We know from Exhibit 35, which you'll get when you go back to deliberate, that Mr. Reed responded to the defendant, and we know what he said. He said, "Yo, what up?" To which the defendant responded, "Do you not get, I said call?" And Mark Reed responded to that, "I can't right now, bro. I'm in Bristol." And then we have these messages. So Mark Reed responds, "Yo, what's up? I don't want this on Facebook. Call me." And he gave his number. Facebook is too choppy. It's too notch. I don't need stuff like this on message. I don't want it on Facebook. I don't want it on Messenger. I don't want it preserved in time. What's the defendant so concerned about here? What's he worried about being captured or memorialized? It's evidence of his crime. It's evidence of his criminal conduct. It's evidence of his theft of those firearms. And here they are. I have something right now that you've been looking for. For a grip, bro. Hit me up. ASAP. Hit me up. I have something. Not someone else, not some mystery man. I do. And Mark Reed responds, "If it's metal, I want it." And Mark Reed came here and he told us what metal meant when he was sending that message. He was talking about firearms. If it's metal, I want it. And you heard him say, it was easy to move firearms. Quick money for firearms. The defendant responded, "It is, bro. The big boys." Remarkably simple case, ladies and gentlemen. It's the big boys. The big boy metal. Mark Reed responds, "How much?" Remember, he's interested. "I can't hold it. First come, first serve." First come, first serve. This man was in a rush to get rid of stolen property, property that he had stolen. He didn't want to be caught with him. And then what do we have here? We have the unsent Facebook messages. And when Mark Reed was here, I asked him, what was in those messages? And he looked at all of you and he told you what the messages contained. They were pictures of an AR-15, Stag Arms AR-15, and a Mossberg 500 pump-action shotgun, a 12-gauge. The two guns that had been stolen the night before, stolen by Adam Montgomery. And why did he unsend those messages? It's what we've been talking about. He didn't want evidence of his crime preserved in time. Mark Reed was able to come here and talk about it, though, tell you exactly what he saw then. We also have the context of the rest of the messages that explain what he saw. I want, or how much I want. To which the defendant responded, which one do you want? Both of them or which one? So we're talking about two items, both or which one? Price of each. And then there's another message that's unsent. And then the defendant says, but we can work something out. What's some other stuff? This is why I need you to call me. But I literally have people blowing me up right now as we speak. But you my dude, so I called you first. I literally have people blowing me up right now as we speak. And he saw that there's another missed call. He's trying to get a hold of this individual, trying to call him. Mark Reed says, I want the 12 gauge, but I don't got 3B. I want the 12 gauge. Again, the Mossberg 500 shotgun, pump action, 12 gauge shotgun. But I don't got 3V. Because 8 get a V pick up and down. And we heard that up is a stimulant, meth, or crack. Crack. Up is crack. Down is heroin. And we heard that this is a communication that's disguised. It's talking about drugs, but they're using other words for them. And Mr. Reed explained what those words mean. Up, crack, down, heroin. The defendant responds, I'll take it. Now let's back up to that story that you heard. And I said I was moving on, so I apologize, but I have to say this. The defense story about the defendant being some proxy for someone else, just negotiating the sale for a buddy. You were told that Ishmael Garcia was the defendant's supplier, that he supplied him with drugs. The defense then got up here and said, oh, well, he was selling these guns to get drugs to give to his supplier of drugs. So I'm selling guns to get drugs to give to the person that supplies me drugs. That's what they got up here and told you. I'll take it. How much? I'll take a stick for the pump. And Mark Reed told us that a stick means a stick of heroin or fentanyl. A finger, which is 10 grams. But I also need like $80 cash. And you heard about a message from September 25th where the defendant says that he's facing eviction, that he needs to get the bread. He needs the money. So I'll take a stick for the pump. I will take a stick for the pump. Not Ishmael, not Manny, me. I will. But I also need like $80 cash. I can't wait around, bro. I can't wait around with it, bro. So I mean, if you hit me up before anybody else does, then it's yours. But if somebody else comes here with the bread, then I got to take it. Let's unpack what that statement says. I can't wait around with it. What are we talking about in this conversation? We're talking about the stolen firearms, the big boys. He has them. He can't wait around with them. They're in his possession. So, I mean, if you hit me up before anybody else does, remember there's hundreds of other people that he's reached out to that are hitting him up for these guns. And it's yours. But if somebody else comes here, I'm going to sell them. Here to my house. Remarkably simple case, folks. A conversation so frozen in time. He puts himself with the guns that he had just stolen, and now he's offering them for sale. If somebody comes here with the bread, then I gotta take it. Because we need the bread ASAP, bro. And what else does he say? We're about to be kicked out of my any day now house. And I told you about the earlier message. And again, you're gonna get all these messages. You're gonna get the actual verbatim statements. You'll also get these photographs. If somebody comes here to my house, we are about to be kicked out any day now. And you heard from Kayla. She told you who lived with them back then. The defendant, herself, their 3 children, Seamus, Declan, and Harmony. Ishmael didn't live with them. Remarkably simple. Ishmael wasn't one of their housemates. Manny wasn't one of their housemates. The 2 of them and their 3 children. And then we have the messages from later on that day, almost 3 o'clock, where Mark Reed says, yo, remember he's interested. Yo. And then a phone call, the defendant calling him. And again, this is on October 3rd around 3 p.m. The defendant says, you missed out. And what's the next communication, folks? October 2nd, or October 7th. October 7th, just a few days later, and what is the defendant saying? Got fire up and down, and Tina. Let's unpack that statement. He's offering these guns for sale, for drugs, for money. He says you missed out. And then what does he say here? He's saying, I have drugs. Got fire. Up, crack, down, heroin, and Tina. And what did Detective Dunleavy tell us Tina means in drug language? He said it means methamphetamine, crystal meth. And who sold crystal meth back then? And who had the defendant's number in his phone back then? Under Montgomery Adam. And who had that firearm 20 days later? This is a remarkably simple case, ladies and gentlemen. Again, those are the defendant's statements. We all agree that those are the defendant's statements. He wasn't doing this as some proxy for some other person. He was doing them for himself. He refers to himself and only himself as needing the money. He refers to himself and only himself as having the guns. He refers to himself and only himself as needing the drugs. He refers to himself and the people that live with him as facing eviction. Ladies and gentlemen, he provided us in those messages all the evidence we need to find him guilty of not only the mere armed career criminal, but also the receiving stolen property, also the theft by unauthorized taking for both the rifle and the shotgun, the two guns that they were discussing in those communications. And so now I want to talk about the evidence that corroborates his statements, what he said in those messages, what he said to other individuals, people that were there at that time. And when I discuss this, I want to remind you, these folks, they weren't in cahoots with the police. They weren't in cahoots to play Get Adam Montgomery for some unknown reason. These are folks that weren't connected, except for Tara Hilbert and her partner, Josh Zimmerman. There were folks that didn't like the police. And there were folks that had no connection with anyone else. If they wanted to cook this up, ladies and gentlemen, they wanted to get the defendant, wouldn't all of their stories align? Isn't that what you heard from the defense? We're going to say all of their stories align? No. You heard their statements. You heard their testimony. They all offer one piece of the puzzle. They all offer some detail that puts one or both of those guns in the defendant's hands. They weren't in cahoots. These people don't know each other. They don't care about each other. They didn't get together and say, oh, how can we cook this up? I want to talk about their statements and how they corroborate what Adam Montgomery said. First, the type of guns. Kevin LaBelle came in here. He described the firearms that he saw that defendant holding, the ones that he was offered for sale. He described them down to a T. The make, the model, Mossberg 500 pump action shotgun, model 500A. That's what we got from Kevin LaBelle, the type of guns. The shotgun, the Stag Arms AR-15 rifle that he saw that defendant with. He said he bought one of the guns, shot one of the guns. He tells us what type of guns they are. And Mike Sullivan, remember, we both agreed that he told the truth back in 2020. They told you that. He came in there and he told what he knew. And he said the defendant had both of the framed firearms. He had both of those guns. He didn't just see them, he held them. Shotgun and the AR-15 rifle. Mark Reed, again, describes the guns down to a T. Make, model. He saw them in the pictures the defendant sent him. Only the defendant sent him. Kayla Montgomery, she describes both the shotgun and the rifle. And yeah, she doesn't know the type of guns that they were, the exact make and model. She knows that it was a rifle, and she knows that it was a shotgun. And she's not a gun person, ladies and gentlemen. She never said she held the guns. She didn't. She told us that she didn't. She doesn't like guns, doesn't like them in her house. Still, she came here and she told you specifically that the gun that had been moved from the attic to under their bed, the shotgun that the defendant later went and shot with Kevin LaBelle, she got into a fight with him over that. She was trying to stop him. She didn't want him leaving because he's a felon and it was a stolen gun. Kim Frayne corroborates the types of guns. And so does Chris Frayne. Kim Frayne, the victim in this case, the victim who sat up there for hours on cross-examination and told the same story over and over again. And we talked about how it would be different than what she initially said. She didn't believe that her friend would betray her like he did. She didn't say that he was there that night initially. And she clarified that in her 2019 statement. He was there. And he clarified that in his statement. She corroborates his statement, ladies and gentlemen. So we have the type of guns. These are the individuals that saw Adam with the AR-15. These slides aren't blank. These are witnesses who saw him with the AR-15. And again, we have Mark Reed, the messages that he was sent, that he described, seeing these guns. Kevin LaBelle. And Kevin LaBelle, let's talk about him for a moment. You heard from law enforcement, you heard from Detective Dunleavy that he had 3 interviews with Kevin LaBelle. And we heard from Kevin LaBelle that in those first 2 interviews, he said that he had seen the guns He said the defendant offered him the guns for sale, but he didn't buy them. And you heard that after detectives spoke with Kayla Montgomery, after they spoke with Kayla Montgomery, they went back and interviewed Kevin Lebel, and he said, yeah, I bought the gun. I bought the shotgun. Someone that has no business being around firearms. They talked to him about his criminal history. They got his convictions out. He's a registered sex offender. You heard that. Someone that has no business being around guns, being anywhere guns are. And he's implicating himself. He's implicating himself in criminal activity. Is that to get at the defendant? No, he said he wanted to be here. Charges that he can face for providing that information, implicating himself, just like every witness did who came in here and testified. They all implicated themselves to some degree in criminal conduct. What you got from him was his admissions, which corroborate the defendant's statements. His admissions to his own criminal conduct, which corroborate that defendant. And he described the defendant with an AR-15. He also is corroborated by Kayla Montgomery. Again, she saw the rifle. Mike Sullivan, who said he held the rifle, and he was sure, 100% sure, that he saw the defendant sell it. That the defendant walked up to his apartment and he said, no, 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 that can't come in here. That defendant with the gun. And he said he didn't testify to the shotgun because he wasn't 100% certain, and he only wanted to come in here and tell you the truth. That's what he said. And we agreed that he was telling the truth back in 2020 when he made those statements that the defendant, and only the defendant, had those two long guns. Tara Hilbert. What did we hear from Tara? We heard that the defendant was scared about the FBI or ATF coming after him for selling guns. And she specifically said, he mentioned when he lived at Guilford Street, selling an AR-15 rifle, one that he hid in the walls in his attic. Josh Zimmerman corroborates that the defendant said he had a rifle that he sold while he was at Guilford Street. This is a remarkably simple case, ladies and gentlemen. These are the witnesses that corroborate that Adam had the shotgun, this defendant. Again, Mark Reed, he saw both guns. The defendant unsent those messages. Kevin Lebel. What did we get from Kevin Lebel? I bought the shotgun. I had it. I sold it back to him for $1.5 grams of crack. Kayla Montgomery. Remember that fight that she told you about where she was trying to help him? She was trying to prevent him from leaving. She didn't want him getting in trouble. She got emotional up there on the stand because she was reliving that event. That's evidence that you can take back to the jury room with you when you go to deliberate. That's evidence that you've gotten in this case. Her reliving that event on that witness stand under oath. The story about a shotgun that defendant had. And we had Mike Sullivan. He put that shotgun in the defendant's hands. And again, he said he held them. I only want to be 100% honest. Wrapped in a blanket or a sheet, a little detail like that, corroborated by all of these witnesses. The defendant said he wrapped it in a blanket or a sheet as he was leaving the home. That's what he told his wife. He wrapped it up as he was leaving. And what did Kevin Lebel say? That when he brought those guns down from the attic, they were wrapped up in a sheet or a blanket. What did Kayla Montgomery say? That he stored them upstairs in a sheet or a blanket until he moved them downstairs under their bed. Little details. Kim Frayne, they were stored under our bed in a sheet or a blanket. Chris Frayne, they were stored in our bed under a sheet or a blanket. Minute details that these witnesses remember after several years. Remarkably simple. And the conversation about the camera. We know there were no cameras that day. No cameras. This story that Kim Frayne concocted about cameras, why would someone do that who traded these guns? Think about that. They're saying she traded the guns for drugs. Why make up this story? Why go to his wife with this story about cameras? Why play detective with him? Why try to get him to admit to this? Remember, everyone that they associated with back then knew that he stole the guns. Everyone told her that. Mike Sullivan said the same thing. Everyone knew. And why did everyone know? He was offering the guns to hundreds of people. He had hundreds of people hitting him up. This wasn't a secret back then. Everyone knew. And this camera conversation corroborates that the guns were actually stolen. Why would someone that traded the guns for drugs make up this story, concoct this story to get the defendant to admit what he had done? And who corroborates this conversation other than Kim? Mike Sullivan. He was there for one of them. And then when they left, the defendant said, "No way, I would already be in jail if she had cameras." Kayla Montgomery corroborates that this conversation several years ago, it happened. She told the defendant and he was concerned. And that's how we know that when he left, he concealed the guns. She told us that the defendant was concerned. Adam at the crime scene, giving himself the means to steal these guns. Each statement you have from Kim differs slightly, but in 2019, she told the police that Adam was there. She said that he was there. Who corroborates that the defendant was there? Kayla Montgomery. She knew he was going there. They were going to get drugs. He was going to bring drugs back to her. Mike Sullivan. The defendant confessed to him multiple times. Of course he was there. And each statement by the defendant, including the jail call that you just heard, corroborates that he was there. He had the means to do this. He had the opportunity to do this. Remember, she was sleeping in each of his statements, sleeping, not crashing, not doing anything to get drugs, sleeping. And what did she say? When confronted with this crashing theory, she said, "I needed to sleep. I'd been up for days. I needed to sleep. I slept." That the guns were stolen, the defendant told Kevin LaBelle that. Kevin LaBelle said that he knew the guns were hot. He knew that because the defendant told him. Kim Frayne has said from the get-go, from her first statement, the guns were stolen. I didn't trade them. She came in here, she looked at all of you, and she said, "I didn't trade them. The guns were stolen." Mike Sullivan knew that the guns were stolen because the defendant offered to sell him the stolen guns. The defendant admitted to stealing the guns. Kayla Montgomery, again, the defendant confessed to her. Mark Reed, he said he knew the guns were hot. That was his business. He's a changed person now, but that was his business. Chris Frayne, he also said the long guns were stolen, that he didn't believe Adam when he came and told him about the trade to Ish for the 380, not the long guns. The guns were stolen, and that the defendant obtained the guns. Mark Reed corroborates the defendant's statements that he obtained the guns. He told you what was on those pictures. You have the context of that communication that he had with the defendant. Kevin LaBelle saw those two guns, described them to a T. Kayla Montgomery, the rifle, the shotgun. Mike Sullivan describes the guns, the tactical shotgun that he saw the defendant with the extra ammunition on the side. The same description that Kevin LaBelle gave, the same description that Chris Frayne gave. Mike Sullivan, who saw the defendant with these guns, and Kim Frayne, who knew that they were taken by him. Everyone knew that they were taken by him. But the defendant possessed the guns. Again, a long list, not a blank slide. People that saw him with the guns. that the defendant sold or disposed of the guns. The same individuals, the witnesses that came in here and testified to all of you. There's no question, folks, that he stole those guns, that he possessed those guns, and that he sold those guns for drugs and or money. The statements that we got from those individuals, they corroborate the large details and the small details. The details like the blanket, those are small details. And the large details like his confessions, his admissions, seeing him with the guns. Corroboration of the defendant's acts. Again, if all of these witnesses were in cahoots to get that man, all of those boxes would be checked. There'd be a check next to every one. I's dotted, T's crossed, check next to each one of them. But what do we have? We have the witnesses coming here to you, telling their bit of their story, what they saw, what they heard, what they in fact did. This wasn't as the defense called it, a case about getting the defendant. This was people coming in and telling you what they had seen, what they'd heard, what they'd done. I want to talk about the law. But before I do, we heard a lot about criminal histories in this courtroom. Were those criminal histories, did they matter? Did they do anything to change the facts that we heard here? The only criminal history that matters in this courtroom is the defendant's, convicted on 3 or more occasions of the requisite criminal felony offenses. Being a career criminal, in other words. You were read a stipulation. You read a stipulation. The parties aren't in dispute that he has those requisite felony offenses. His criminal history is the only one that matters here. So again, armed career criminal, 2 counts of armed career criminal, 1 count for each of the stolen guns, 1 count for each of the guns that he possessed. Theft by unauthorized taking, again, 1 for each of the guns. Receiving stolen property, 1 for each of the guns. So, armed career criminal, like I said, career criminal, possess a gun. And the judge is going to tell you, when she reads the law on armed career criminal, that it contains 3 elements. 3 or more qualifying convictions, not in dispute. Knowingly having or owning or having control over the long gun or rifle, depending on the count that you're looking at. So knowing, possession. There's the rifle that was recovered from Jonathan Sargent's house with pounds and pounds of meth, with money, with other guns, with crystal meth, heroin, fentanyl. He received 13 years for trafficking in drugs, himself being a felon in possession. Let's talk about receiving stolen property. So with receiving stolen property, the judge is going to tell you that it requires proof that the defendant knew that the 2 guns had been stolen, that he received or retains them with the purpose of depriving the owner thereof. We know that he knew that the guns were stolen because he stole them. Everyone was talking about these stolen guns. The victim confronted him about the stolen guns, and he retained them. The witnesses all told you that the guns were stolen. And was his purpose to deprive the owner of those guns? Yes, we see his purpose. We have it in his messages, selling them to someone else for drugs and money, hiding them in the walls, in the attic. So armed career criminal and receiving stolen property, there's a requisite timeline associated with that. and that's September 29th, 2019 through October 22nd, 2019. That's the time period when he had those guns and when he held on to those guns, so receiving. September 29th, 2019 through October 22nd, 2019. So finally, theft by unauthorized taking, again for the AR-15, for the shotgun. The judge is going to tell you that the law requires proof that the defendant obtained or exercised control, unauthorized control, over the rifle and shotgun with that same purpose to deprive Chris Frayne of his guns. He did that when he took the guns out of the Frayne home. He acted with intent to no longer give them back. Remember, Kayla just wanted him to give those guns back. He didn't, he sold them. So with the intent to deprive the owner thereof. And the timeline associated with those two charges, the theft by unauthorized taking, that's September 29th through October 3rd. Remember the week that Christopher Frayne was out of the house. He was gone to work. So if all of these witnesses were in cahoots, they all wanted to get the defendant, Kim Frayne would have just said he did it. She wouldn't have made this story up about the cameras. And that's not what we got from Kim Frayne. She said she fell asleep, that when she fell asleep, the defendant was still there. When she woke up, he was gone. The guns were missing. And why didn't he want those messages, those Facebook messages? Why did he want to hide them from you? Because he knew how damning they are. And how does common sense tell us that we know he was trying to hide them from us? Well, go back, look at the Walmart footage in your deliberations. There's a camera on that Echo ATM machine, and he wanted to be out of view. And we know that he was out of view. He had control over someone else, that he had deposit those phones, recycle them. He didn't want to be associated with them because he knew what was on them. He knew that that phone linked to that account. Remember, he logged into the account on that phone, the Facebook account, linked to those messages. He wanted nothing to do with them. And yet he was captured on camera, linked to that phone being deposited in that machine, that phone tied to that account, tied to those messages. He was in control that day, enough control to get someone else to dispose of his evidence for him. And ladies and gentlemen, I mentioned something just then, common sense. That's what you take back there with you. Common sense as to why a wife would lie to protect her husband. Common sense as to why a multi-time convicted felon would lie about possessing a firearm. Common sense as to why the defendant would say he didn't want this stuff on Facebook and why he'd go to these extensive lengths to discard of all of that evidence. It's not surprising that when you get the truth from so many different sources, it all fits together. Not perfectly, but it all fits together. And you have a story from it. Little bits given by each witness throughout the course of this trial. Little bits that put each gun in that man's hands. The defense wants you to ignore all of these witnesses. They want you to ignore the messages that we've just gone over, that you've seen during this trial. I want to remind you, the state doesn't choose its witnesses. He chose them. He chose these people. He chose the soft targets. And the undeniable truth in this case that you heard throughout the course of this trial, that he had both of those guns, that he stole them, that he possessed them, that he sold them, means that you can return only one verdict. And that's the verdict that justice demands. That's guilty with respect to each charge for being an armed career criminal for receiving or retaining stolen property, and for theft by unauthorized taking for both of the firearms. In closing, simply put, the defendant was told, no, you can't do this. No, you can't possess firearms, after being convicted of certain requisite felonies. And he chose to possess the firearms anyway. That's the truth of this case. That's what you've seen. That's the truth that the defense wants you to ignore when you go back to deliberate. All of the witnesses that saw or heard the defendant with these guns or heard his admissions to stealing them. And you were all chosen because of your common sense, because of your ability to reason. And that's what you bring back there when you go to deliberate. And the state is asking you to find him guilty on each of the counts that you've been presented with.
All right, ladies and gentlemen, it's time for me to complete my final instructions to you. Maybe this is a good time. Just stand up if you want to take a stretch. I suspect these instructions will take about 10 minutes or a little more, and perhaps your lunches will be here, and you can begin deliberating. So in just a minute, I will begin my instructions. But as I say, this is a good time to take a short stretch. All right, members of the jury, I'm now going to complete my instructions to you. As I said to you at the beginning of this case, you will have all of these instructions, the ones I gave to you at the beginning of the case, and I will give to you now in writing. I will send back as many copies as the jury wants, so please just listen carefully. Please remember that in order to reach a verdict in this case, whether it is guilty or not guilty, your verdict must be unanimous. Prior inconsistent statements. In deciding whether to believe a witness, you may consider whether the witness made statements before trial that were not consistent with the witness's testimony at trial. Thus, if the witness made an inconsistent statement before trial, you may use that statement in deciding whether to believe that witness's trial testimony. Keep in mind that you may not use the statement made before trial as proof that the facts in the statement are true. The statement made before trial is only to be used by you in deciding whether to believe a witness. There are, however, two exceptions to this general rule that prior statements may only be used in assessing witness credibility. If the statement made before trial was made by the defendant or by a witness under oath, then you may use that prior statement as proof that the facts in the statement are true. I'm now going to discuss the definition of a crime and the crimes with which the defendant is charged. A crime is the breaking of a law for which the law provides punishment. All crimes have at least two parts, an act and a criminal state of mind. In deciding whether a person is guilty of a crime, you must determine both what the person's actions were and what his state of mind was. For a person to be guilty of a crime, he must have physically acted to do something that is criminal, and he must have had the particular state of mind. Unless a person both acted to do something that is criminal and had the required mental state, that person has not committed a crime. That means if a person either did not physically act to do something criminal or did not have the required mental state, then he is not guilty of a crime. To understand how mental state works, consider this example. Suppose two automobile drivers hit a pedestrian who was crossing the street. Suppose one of those drivers hit the pedestrian deliberately, whereas the other one did so out of carelessness. The two drivers would be guilty of different crimes, though they both committed the same act because each had a different mental state. Proof of intent. To prove that the defendant has committed a crime, the state must prove first that the defendant did certain acts, and second, that the defendant acted with a certain intent. Whether the defendant acted with the particular intent charged is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all of the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted with the intent as it is charged in each indictment. The charged offenses. On charge ID 2008742C, the defendant is charged with the crime of armed career criminal shotgun. The definition of this crime has three parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant has been convicted of any combination of 3 or more qualifying felonies in this state or any other state under the applicable law. And 2, that the defendant owned or had in his possession or under his control a shotgun. And 3, that the defendant acted knowingly. Certain words in the definition need to be further defined. Possession. A person possesses an item when he has it in his physical custody or exercises dominion or control over it. Possession can be actual or constructive. Actual possession is when a person has direct physical control over the item. Constructive possession is the power to determine the use or disposition of the item. In either case, the state must prove that the defendant knew the location of the item and the defendant knew the nature of the item and that the defendant had custody of the item in the sense that it was in a place where it was under his control. In a case of constructive possession, mere access to the item is insufficient, as is mere presence in the location where the item is found. The defendant must have the power to control the item. Constructive possession can be inferred from all of the evidence presented, including any incriminating statements or any other circumstances linking the defendant to the item. Furthermore, constructive possession of the item need not be exclusive. The item can be possessed jointly with another. The term knowingly. A person acts knowingly when he is aware of the nature of his conduct or the circumstance under which he acted. The state does not have to prove that the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware of the nature of his conduct. The parties have stipulated as fact that at the time of the allegations in this case, the defendant had previously been convicted in this state or any other state of a combination of 3 or more qualifying convictions as listed under the applicable law. That's the stipulation, one of the stipulations that I read to you earlier. Charge ID 2008743C, armed career criminal, rifle. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that the defendant has been convicted of any combination of 3 or more qualifying felonies in this state or any other state under the applicable law. And 2, the defendant owned or had in his possession or under his control a rifle. And 3, the defendant acted knowingly. Certain words need to be further defined. Those words are the same as the words that I defined for you in the first armed career criminal charge, so I won't read those again, but you should use the same definitions of possession and knowingly. I've also included the stipulation under this armed career criminal charge. On charge ID 1964101C, the defendant is charged with receiving stolen property, a shotgun. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant received or retained the property of another, to wit, a shotgun, firearm, and 2, the defendant knew that the property had been stolen or believed that it had probably been stolen, and 3, the defendant acted with a purpose to deprive the owner thereof. These are the elements of the crime of receiving stolen property. Certain words in the definition need to be further defined. Receives means acquiring possession, control, or title. Property means anything of value. Knowingly is the same definition as I read to you earlier. That's the same definition to be used here. Purpose to deprive means to have the conscious object to withhold property permanently or for so long as to withhold property permanently or for so extended a period, or to use under such circumstances that a substantial portion of its economic value or the use and benefit thereof would be lost. Purposely. A person acts purposely when his conscious object is to engage in certain conduct. The state must prove that the defendant had the conscious object to engage in this conduct. The key words here are conscious object. To have a conscious object means to have specific intent. It means that the defendant desired to engage in certain conduct. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to do a particular act. Charge ID 1964100C, receiving stolen property, the rifle. The definition of this crime has three parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove, 1, that the defendant received or retained the property of another, to wit, a rifle firearm, and 2, the defendant knew that the property had been stolen or believed that it had probably been stolen, and 3, the defendant acted with a purpose to deprive the owner thereof. These are the elements of the crime of receiving stolen property. The words that need to be defined are the same as the words that I defined for you in the first receiving stolen property indictment, so I won't read them again here, but you have them here for your use. On charge ID 1964009C, theft by unauthorized taking, shotgun. The definition of this crime has three parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant obtained or exercised unauthorized control over the property of another, and 2, the defendant acted with a purpose to deprive another of the property, and 3, the property was a shotgun firearm. These are the elements of the crime of theft by unauthorized taking. Certain words in the definition need to be further defined. To obtain means to bring about a transfer of possession or of some other legally recognized interest in property. Property means anything of value. Purpose to deprive means a conscious object or intention to withhold the property permanently or for so long or under such circumstances that a substantial portion of its economic value or the use and benefit of it would be lost, or to dispose of the property under circumstances making it unlikely that the owner would recover it. Charge ID 1964098C, theft by unauthorized taking, the rifle. The definition of this crime has three parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant obtained or exercised unauthorized control over the property of another, 2, the defendant acted with the purpose to deprive another of the property, and 3, the property was a rifle, firearm. These are the elements of the crime of theft by unauthorized taking. Certain words in the definition need to be further defined. I've defined those for you in the first theft by unauthorized taking. Those same definitions are utilized here. In conclusion, members of the jury, let me say that this case is important to both of the parties, the state and the defendant. The principles of law that I have given to you are intended to guide you in reaching a fair and just result. You are to exercise your judgment and common sense with honesty, understanding, and due deliberation. As I said before, you should decide this case without passion, without prejudice, and without sympathy. It is your highest duty as officers of this court to conscientiously determine a fair and just result. Now again, as you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout the trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which he has been charged. And the defendant has no obligation whatsoever to prove his innocence in this matter, and that includes the right not to testify if he so chooses. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to the charges before you. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the offense charged, you must find the defendant not guilty. On the other hand, if you find that the state has proved all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. And I remind you, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. As I mentioned, we will select a foreperson at random at the end of these instructions. The foreperson acts much like the chair of a committee. He or she should make sure that you take up the issues that I have described, and should make sure that each juror has a full opportunity to present his or her opinions and arguments. I suggest that deliberations involve several components. You should each think for yourself about the evidence and the law. You should speak up and let your fellow jurors know your opinions, views, and positions. You should listen carefully and keep an open mind as to what your fellow jurors have to say. And you should make every reasonable effort to reach a unanimous agreement. The verdict that you reach must be a unanimous verdict and represent the considered judgment of each juror. In order to return a verdict, all 12 of you must agree on your verdict. As you deliberate, try your best to work out your differences. Do not hesitate to change your mind if you are convinced that other jurors are right and that your original position was wrong. But do not change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. If any questions concerning the law should arise during your deliberations, the foreperson should write out the question, sign, and hand it to the court officer. The court officer will bring them to me, and I will respond. You should take as much time as you like. When you have arrived at a verdict, let the court officer know, and you will be returned to the courtroom where the foreperson will render the verdict orally in response to questions that the clerk of court will ask. Please bear in mind in your deliberations there can be no communications with anyone other than the other deliberating jurors in the case or the bailiff. You are not to use your cell phones or smartphones to communicate with anyone, check email, or use the internet. Your verdict in this case must be based solely on the evidence presented at trial and the law as I have explained it to you. All right, ladies and gentlemen, we have picked, in this case, we seated 15 jurors, so that means we're going to select 3 alternates. So I have this very advanced technological system that I will use to select the alternates. So the first alternate is juror number 5. The second alternate, juror number 15. And the third alternate, juror number 1. So, ladies and gentlemen, the alternates will be taken to a separate location. You are not to discuss this case with each other or with anybody else. There are times when we do need to utilize the alternates for deliberations at another point. So for now, do not discuss this case, not with each other or with anyone else, okay? We're now going to select a jury foreperson. Juror number 13. Are you willing to serve as the jury foreperson? Yes. Okay. So I suspect, ladies and gentlemen, that your lunches may be here. I leave it to you to decide whether you want to eat lunch and then start deliberating or begin deliberations right away. I remind you, please, the alternates, don't discuss the case with each other or anyone else. Don't do any independent research. All right? Ladies and gentlemen, thank you so much for your time and attention this morning.
All rise for jury.
All right. So thank you, everybody. I think at this point, is everybody that's planning on staying in the building? If you go out at any point, make sure that you leave a cell phone contact information with the court monitor so that you're not far, and if there's any questions or a verdict, we can get to you.
Just in the next couple of minutes. I just want to know what time we should start breaking out some of the equipment here and try to get that out of the way.
You mean in terms of if we're going to use it for other things right now?
I know security staff needs to have their lunch as well, so I just need to.
Oh, are we going to lock it? Yeah, we will, well, hang on, let me check with security. We're going to send back all of the exhibits that have been marked as full exhibits except the firearm. I don't send the firearm back. I think the court officer can let them know if they need to see the firearm, that they need to let the court officer know, and then I would bring them back into the courtroom and we would show it to them here.
So usually the recorder takes the exhibits back, right?
Yes.
So she would be the one informing them that the gun's not coming back and that if they want to see it, they have to call a court officer.
Yeah, I probably send a clerk in with her to do that.
Okay.
Yeah.
Great.
Yeah, typically I would maybe tell them here, but I didn't tell them here, and so, but I think no one has an objection. I'll just let the clerk tell them that if they want to see the firearm's not coming back, but if they want to see it, they can ask, and I'll bring them back in.
Thank you.
All right, anything else? No? Okay. You're all set.
That wraps up segment number 3. There's more to come. Be sure to press subscribe so you don't miss any of our coverage and the firearms trial of Adam Montgomery. I'm Tony Bruschi. Stay with us.